suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
There he is, our real good lawyer. And there you are on the phone lines, although I do have a couple of lines free for David Whiting, celebrated Melbourne solicitor, who can help you with all of your legal problems. David, good morning.
Good morning, Virginia.
We never have lines free. You're not...
No, it's... Okay, I do apologise. I've got to get more relatives to ring. I understand the system. Yep.
No. We know there are problems out there, and we can help if you'd like to call in 1300 222 774. Did we have homework?
We didn't, but we had something from the week before.
Mm-hmm.
Claire from Richmond rang and she was concerned that the house next door, which she described as a dump, was going to be sold and would be replaced by a 2-storey dwelling, and she was concerned about what impact that would have on her solar cells that she'd recently spent a fortune putting in.
Good question.
So during the week we got an email from a caller from Maribyrnong who's saying, as a follow-up, was saying that the Maribyrnong Council has provisions in the planning scheme relating to overshadowing and solar panels. So I went and looked at the Yarra planning scheme, and it now appears that in every planning scheme in Victoria there are a series of provisions that are designed to protect, not to guarantee the protection of, but protect people who've got solar panels and what we get from them.
Okay.
So if Claire is listening, it's clause 54.03-5 of the planning scheme for Yarra. And yes, impact upon your solar panels, and they need to be existing, not prospective. If I'm taking away your potential for solar panels, tough.
Okay.
If I'm infringing on your solar panels, that is a factor.
So this is going to be council by council?
No, it's really very clever the way we do planning schemes now. They have a whole series of uniform provisions. So this one was introduced into every local planning scheme in April 2020.
Okay.
So
right.
It's there, but you've got to know that it's there. And so, yes, so it's uniform.
Gee, this could really affect multiple dwellings and development in that way. If a smaller place next door, for example, has those panels on their roof.
It's an impact. It's one of the factors that they take into account.
One of them.
It is not a guarantee of refusal.
But if you could put that together with loss of light and loss of amenity and that added in there as well, then you'd have an argument with council?
Well, you've got an argument from council just because you've got solar panels. Mm-hmm. But it might well be if the solar panels were moved 3 feet, then there would be a lesser impact. There are all sorts of ways to look at it.
Interesting.
But solar panels is a factor, but for existing, not prospective.
Okay. And was there another issue?
No, that was it.
Just the one. Okay, yep. Let's get to your questions. 1300 222 774. Natasha in Coburg, what would you like to ask David Whiting?
Nothing.
Okay.
Hello? Yes.
Hi, Natasha. You're on the air.
Hi, good morning. Yes, I live in an apartment block and had a neighbour move upstairs about 10 months ago, and pretty noisy. I left it a month or so and then just popped a card into the letterbox saying, oh, look, I don't know if you know, but the floors seem to be pretty thin and I can hear, so, FYI. So the noise kept going. After 4 days, I buzzed his apartment and he came downstairs to the lobby and we had a bit of a chat. But he was quite hostile with me, and the end of the conversation was, I know where you live, I know where you work, I know you've got a kid. If you complain to anybody, you'll be sorry. So That was a bit of a problem. So I went to the body corporate and I said, look, I'm really fearful. I don't really want to get the police involved, but this is the situation. And they said, well, look, it's a social housing rental, and if you just keep a diary of the noise, then we'll submit it to social housing and they can have a chat with him or what have you. And I said, well, they'll know that it's me though. So for 8 months later, and I'm a nurse and I work shift work, and I've taken a lot of days off because I've just been too tired to go to work.
Yeah.
It's an ongoing issue, and I don't really want to sell up, but I don't feel safe enough to kind of say anything. So what do I do from here?
And have you got your diary?
Yeah, I've kept a couple of diaries over a succession of weeks.
Yes.
Off and on, but I sort of feel a bit confident and brave, and then I think, no, I don't want to do it.
Natasha, have you had any interaction with the neighbour upstairs since your conversation in the foyer?
Yeah, so since that conversation, I've tried a couple of times to try and warm him up a little. He was actually quite good with me on one occasion, but then his friend came up who also lives on the same floor, and he actually escalated things, and then it all turned quite bad.
Pear-shaped again.
Yeah, it went pear-shaped. So I've tried a couple of times. Even my sister, I even got, we're in a common area and we tried to have a chat just to sort of warm things up again, but he's just not having a bar of me. So I don't know what else to do.
Your catch is that, based on the first interaction, you would have reasonable prospects for an intervention order to get him to leave you alone, right? Where you're at the moment is that you have the right to go to the... I'm not going to be very helpful. You can go to a magistrate's court and you can get an order that keeps the noise down upstairs or requires him to keep the noise down. Whether that works or not, I don't know, because as a social housing tenant, I'm assuming that he has very little in terms of financial assets, so you would be spending money to defend a position without having the ability to recover the cost of the process. So that's the issue. Though I'm not very helpful to you, I do know that one of the problems is that everybody seems to be really keen on wooden floors these days. They echo beautifully if they're not soundproofed.
Yeah.
So we have to leave it there?
Yeah, can't help.
Sorry about that.
Well, can't help practically, yes.
Natasha, we are sorry about that, but thank you for calling in. Peter in Bentley. Hi, Peter. What's going on?
Hello. First thing I need to do is to pull over to the side of the road. To say long-time listener, first-time caller would be an understatement. David, I've been listening to you for longer than I think, I've been listening to you for a long time.
Okay. Peter,
right.
do you have a quick... Do you want to give you a moment? Why don't I give you a moment and you can sort out pulling over. I'll come back to you in a second. Just hang on. But we can't really waste time with that. So we'll come back to you in just a moment. Billy in Frankston. Hi, Billy. What's happening there?
I was scrounging up some old bricks, and I got a conviction 10 years ago or more.
Yes.
And if I had realised at the time, I probably would have got a solicitor and fought it and tried to get a bond. But I'm wondering, is there any process to overturn it because I'd really love to go to America, but I've got a conviction.
You've got to understand, Billy, that in order for your conviction follows what's called the finding of guilt. All right?
Yep.
So what happens now is that most visa applications say, has there been a finding of guilt? Whether or not they move to a conviction, you can still apply to go to the US. It's probably, however, going to be a paper transaction rather than an electronic transaction. I've had some success in the past assisting clients to get visas. You don't need a lawyer. You should be able to do it yourself. But you just simply need to make disclosure, and there it is, if you like.
Is there any process at all to try and get that conviction overturned as an appeal of some sort?
No, I'm sorry. The answer would be, here we are. All we know is you're Billy from Frankston. Did you take the bricks?
Yes.
And what's the basis for getting the conviction overturned?
I was just scrounging rather than... I knew that they were rubbish to...
They're someone else's bricks and you took them.
Yeah, but yeah. I knew that was going to cost that. I went nuts.
No, Billy. Here's the way it works. In order for court to find you guilty, they had to find that you had committed the offence. The only basis upon which you would be able to get the conviction overturned is I didn't commit the offence.
Okay.
All right. So. But it won't prevent... And there's also a provision relating to stale convictions in Victoria. So it may well be... you're still required to disclose it to the authorities, but there is a provision relating to stale convictions.
Yes, I wanted to ask, so does it just follow logically that he won't get the visa because he has this conviction, or is there some leeway usually shown by the consulate?
But the electronic process for a visa to the US is you probably go offline and they want to know more about the conviction.
Okay, all right.
But it won't stop him getting the visa.
All right.
It will be a bump in the road.
All right.
Yep.
So if the main issue here is getting the visa, there is a way to get there.
Yes, there is.
Without trying to overturn that conviction.
Yep.
Okay, good luck, and we hope that works. Peter, sorry I just had to hold you off for a second there. I hope you pulled over by now. What's your question, Peter?
very quickly. In the olden days, one used to be able to have a prenuptial agreement so that both parties agreed that if they split up, the money wouldn't become a problem. Prenuptials have now gone and have been replaced by a binding financial agreement.
Yes.
I'm led to believe that a binding financial agreement these days is probably not worth the paper it's written on.
I would disagree, Peter. Binding financial agreements have been challenged, but if there's going to be a challenge, the challenge is essentially on one of two bases. The first basis is that there was an inequality of bargaining power at the time that the agreement was entered into, and that relies on a high court case where there was a bride from overseas, a local husband, and the binding financial agreement was produced just before the wedding. So they felt that there wasn't an open and frank discussion at the time. Somebody felt pressured into it. The court agreed. The other one is that the agreement doesn't provide for the circumstances that you're currently facing. So binding financial agreements made all the time. The general aim is to allow them to be enforced, but there are exceptions when it doesn't work. So you're running from the presumption that a binding financial agreement will not be enforced. Work from the presumption that it will be given effect to.
Thank you.
Thank you.
Thank you. Thanks for calling in and thanks for waiting a little bit as well. Appreciate that. 1300 222 774 if you have some legal issues to be dealt with. Simon in Rowville. Hello, Simon. What's your question?
Yeah, good morning, Virginia. Good morning, David. I'm buying a house for the very first time in my life, and I have a letter from my conveyancer suggesting I should be buying a thing called titles insurance.
Yep.
Now, it's $550 odd for I'm not really sure what. So I suppose my question is, hey, what do I actually get for this? What will they fix me up for? And is it worth it?
Generally, no. Generally, no. But then house insurance isn't worth it if your house doesn't burn down.
Indeed.
So, Simon, it's a it's an American product, or comes basically from America, because title insurance is important over there. We have a government guaranteed title, so the ownership of the parcel of land will be governed by there will be a government guarantee in respect of it. If it may be that it offers protection in the event that there is a fraud. So you really need to look and see what benefits you're getting under the terms of the policy to work out whether it's worthwhile.
So would this have covered those people in Queensland who discovered that the house they'd bought for $1.something ridiculous million wasn't actually their house?
I had a discussion with someone some weeks ago. This is where a lady sold the house to them, and there was an issue with a caveat.
Yes.
Yeah. I perhaps we might talk about that one next week, Simon. I'll do some work on title insurance and take it as homework. Does that help?
Well, yeah, that's the best I'm going to get, isn't it?
Okay, it is from me anyway. Thank you, Simon.
You know what? We've decided it will help.
Thank you.
We've decided it will help. That's right. No matter how long it's going to take. Let's hear from Sylvia in Watsonia. Hi, Sylvia.
Oh, good morning. I had a relative recently die, and in her will, she set aside a certain amount of money for grandchildren, which would have been the money coming from the unit she was living in. She, before she died, she'd moved into care, so the unit was sold. So now it's considered a failed gift. As the residual beneficiary, I've been advised that I can sign something called a deed of agreement that will reinstate that clause in the will. Can you just explain to me deed of agreement? And
I'm a pedant, Sylvia. I will not resile from that position. A deed is a form of agreement. So it's like talking about an ATM machine.
It's an agreement.
An agreement. And a deed is a particular form of agreement. There are two possible answers to your scenario. One is that you could argue that the RAD that was paid was in fact the house. So that could be an argument that the grandchildren could take. you, on the other hand, you could sign an agreement which says you recognise that the intention of the will maker was to provide this gift and you're giving effect to it.
Yes, that's what the probate lawyer is suggesting.
So that's where you go. You come along and here's an agreement which, as Sylvia says, the grandchildren should have got, the grandchildren didn't get because of an error in the drafting, or the drafting not failing to take account of the circumstances. You're happy to give effect to it.
Yes.
Now,
and
the question that you need to look at, are you on a pension, Sylvia?
Yes, I am.
So your question that you need to work out is whether or not the making of that gift will impact upon your pension. All right?
My understanding was that if it's done before the estate is settled, then it should not impact. Would that be correct?
That's probably right. Haven't seen the will, don't know for sure, but what you're saying, I mean, let's say you were going to get $100,000 under the will, you're now going to get 70, and therefore have you given away more than your pension entitled? But you also need to work out, Sylvia, whether it makes any difference at all. And it may well be, I have no idea how much was the RAD at your, no, don't tell me, but it may well be that it may be no difference to your pension if you get $450,000 or $500,000. Right? You might lose it in both circumstances. So you need to work out, let's say we treat it as your gift, what then becomes the impact on your pension, taking into account the residue that you get, and what would it be if it didn't affect your pension? You need the answers to those questions.
Okay. We'll leave it there. Thank you so much. Nikki in Brunswick. Hi, Nikki. What's going on?
Hi. Okay, so I've got a golden retriever. I had him at a local dog park where dogs can be off the lead more than a year ago. And he was running around having zoomies with another dog, and he ran into the back of a woman's legs, and she fell over.
Yes.
So she told me at the time that she had a pre-existing issue, that her knee had dislocated several times. I gave her I was horrified, and he's such a gentle dog, he would never hurt anyone.
I must jump in and say I've never heard anyone ever say anything about a golden retriever that was in any way dangerous, so I get it, but go on. No,
that's right. He sits on everyone's feet at the park and wants to be hugged and whatever. Anyway, so I offered my phone number, said that, if I could, is there anything I can do, whatever. And I didn't hear from her until.
So where are we up to, Nikki?
Yes, get to the point,
that was
Nikki.
That was May last year.
Yes.
And then in April, I got a text message which was like a legal letter, basically talking about her. I think she's a lawyer as well, so talking about her.
There are lots of lawyers in Brunswick.
Talking about the impact on her life, and look, I feel really
Nikki,
terrible.
She may well have a claim against you.
Right.
Essentially for failing to provide adequate supervision of your dog, and therefore there is the consequence. What I want you to do is have a look at your home insurance and see if there is cover there.
Right.
All right?
How does the home insurance apply in this situation, David?
Well, it might impact upon the pets that you have and what they do and don't do.
Even if it's outside the home?
Yes.
Okay.
Right? I'm not guaranteeing it. Yes.
No, but can I just say that I'm the type of person who, of course, immediately when I got that text message said, I'm so sorry that this is, I'm happy to pay some money, but I just need to think about it and obviously get some legal advice. I guess my concern is that if I give her some money, then can she come back to me, even though in the text as well she said that she has had a pre-existing knee issue. Can I have
the answer would be if you're going to give her money, you would want a release. You would want a formal contract with her that says, this is it, there is no more. Yep.
No.
Is she directly asking for something, Nikki?
Yeah.
What's she asking for?
I think about $1,500. Yeah.
That sounds to me to be pretty good, but I would be suggesting that you need a document which says, for $1,500, that's it. That's the end of the discussion.
Is it worthwhile, Nikki, paying a bit more money and seeing a lawyer?
Or talk to community legal service and have a discussion about what it ought to look like, yes.
Okay.
Yeah. Okay. Thank you so much.
Thanks,
That's
Nikki.
And Nikki, what's the name of the dog?
Freddie.
And is he behaving himself better now?
Oh, no, but honestly, he's the best dog. Like,
Look, they all are until they knock someone over, right?
yes, that's right. And, the thing is, at a dog park, the whole part of the joy is them being able to...
I know. Look, I know. But even at a dog park, and I think the signs say this, don't they, David? And it makes me laugh out loud. The dog has to be under either effective hand or voice control. You show me a dog that's under effective hand or voice control.
You can at the airport, but that's about it.
Exactly.
Police dogs.
I love seeing it. I love seeing the owner. I'm the owner going, Marco, 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 Marco. You can see the control that I have. It's zero.
Yep.
So it's on me. The onus is on me. And we're coming up against that legal tort of, is it the eggshell skull? Of it doesn't matter if,
yes. But then every dog gets its first bite.
Excuse me? Is that in law?
Yeah, well, the answer, that's not in those words. But yes, everybody gets, the claim against Nikki is failure to exercise reasonable control.
Yes.
The question is, he's never done this before. Everybody gets one go.
One failure.
Mm-hmm.
Melanie and Q, good morning. How can we help? Just quickly.
Good morning. I'll try and be just the facts, man.
Yes.
I'll give you the facts. I've got a leak that's coming in to my property. The body corporate sent over a plumber to investigate. They're saying that they can't seal it or do anything without accessing the apartment above. They think it's a leak coming from the balcony.
Mm-hmm.
The owner of the property has been fobbing off the plumber, the body corporate, not answering or just not giving access. So the plumber can, and the property is vacant at the moment. And it's raining. So
Melanie, the problem is between you and the neighbour upstairs.
Okay.
It's unlikely. It's a question as to an unreasonable flow of water, and we don't know. So if it's a leaking tap upstairs coming down to your property, then we need to know where the leak is. Is it inside property that belongs to the owners corporation, so part of the common property, or is the leak from upstairs? So years ago, I was involved where the membrane in the shower failed upstairs. So every time the shower happened upstairs, my client's ceiling got wet. So they're the things that you need to have some idea of. But
I can't get any idea about that, David, until the plumber can access the property, and she knows that this leak will continue until she. Do I offer to pay half? Do I send her a letter of notice that, a legal letter saying that I'm going to claim for damages?
While it's a matter at VCAT, it's under the Water Act and costs follow the event. So here we are, we're offering, we need to identify the problem and then strike a deal as to who pays and how the work is fixed. That's the kind of letter you need to write to her.
Okay, good luck, and we hope that helps. David, always good to see you. Thank you so much.
You.
David Whiting there, and he'll be back with you next Tuesday as well.